Welcome to the Colorado Trial Lawyer Connection, where Colorado trial lawyers share insights from their latest cases. The pursuit of justice starts now. Welcome back, everyone. My name is Keith Fuicelli, and I am very excited to host another episode of the Colorado Trial Lawyer Connection podcast. This episode is special really for two reasons. First of all, this is our 20th episode. So that is an accomplishment that I'm honestly pretty proud of, because I'm the one that gets to talk to all these amazing lawyers and hear these inspirational cases and pick up tidbits that honestly make me a much better trial lawyer. But this episode is also special because I've got my very good friend Dan Lipman from the law firm of Parker and Lipman on to talk to us about sex assault cases and a sex assault verdict that he recently obtained in what I think is a difficult jurisdiction sometimes in Jefferson County. So without further ado, Dan, thank you for coming on the show.
Well, thank you, Keith. I really appreciate you having me. It's really an honor to be asked to come chat with you today. And I know you and your partner, John Lee, do amazing work, and I appreciate being included on your show.
Well, honestly, the honor is all ours because you, and you're so humble, but you have a national reputation of pursuing these types of sex assault cases that I believe started with cases against the U.S. Olympic team or committee. Could you tell the listeners a little bit about that case?
Sure. I first got involved in this work several years ago when I was approached involving a case where the men's head swim coach was having sexual contact, or allegedly having sexual contact, with a world championship swimmer. And what had happened in that particular case, the first case I was involved with, is the head swim coach was removing this 16-year-old swimmer from the premises every day at about 6:30 in the morning and taking her to his Orange County, California townhome, which he said where they like to have breakfast together 5 days a week, apparently.
Wow.
This was so concerning to the other swim coaches that the other swim coaches, in fact, people that he had coached with for years, had reported him to United States Swimming. United States Swimming was so wanting to protect this coach because there's no dispute, he's a good swim coach, not a good person, but a good swim coach, that they did an investigation and found no cause to remove him, to do anything, which was the most ridiculous investigation ever. In fact, I'll skip through some of the details, but I'll tell you that the lead investigator on that file within U.S. Swimming was also at the same time sleeping with the head men's swim coach.
Wow.
So they kept this coach around, and to no surprise, the minor child kept being abused. She was convinced that when she turned 18, they'd be married. Of course, that's not the case. He was using her to satisfy his own twisted sexual desires. There were several cases spinning off this scenario. One is that United States Swimming went so far to try to fire one of the coaches who did the reporting and turned him in, which was a bad move. So we helped handle that case in conjunction with another lawyer. Then we represented the swimmer who was abused while she was a minor in a case against USA Swimming. So that's how we got started doing it. And we've done several cases against US Swimming. Since then, we've done a big case, several big cases representing 6 different plaintiffs against US Taekwondo.
Okay.
Done cases against a variety of other entities in the US Olympic sports movement. All of those cases have helped teach us how to go about doing these cases going forward.
So forgive my ignorance. I literally know next to nothing about these types of cases, how to pursue them, how to collect on them. Is there no type of federal governmental immunity, or are you able to bring claims directly against USA Olympic Swimming or whatever the entity is?
Yeah, it's a good question. Is obviously you got to look hard at who you're suing because sometimes there are immunity issues. When you're suing USA Swimming or an entity like that, they're called NGOs, which are non-governmental organizations, and they generally do not have immunity. They're a creation of Congress, but don't enjoy the same immunity as other creations of Congress. One of the issues is Congress created the United States Olympic Committee, created some of these entities and provided no realistic oversight, that they're supposed to oversee themselves. That's an issue when, as time goes on, profits and sponsorships and TV time and all that becomes more and more paramount. That was well on display in our Taekwondo case where we sued United States Taekwondo. In a nutshell, in that case, it was a sad story, in my view, of propping up really good Taekwondo coaches who were good at getting medals and good at getting money for Taekwondo, no doubt. And in our view, that they were also rapists, and that there are allegations that are outlined in the complaint that we filed and throughout that lawsuit demonstrate that the six really world champion caliber athletes were made to do certain sexual favors for these people in order to stay on the team. And just in brief, Taekwondo is a martial art. And so we know in almost any sport that the coach has a certain level of leadership, a certain position of power over the people in the program. And that's even more paramount when two things occur. So one, when they start out as minor children, that disparity in power is even more pronounced. And
Absolutely.
two, when we're talking about at this level, that this is not parents driving their kids to practice. These athletes are so good and these athletes are so unique that they are moving away from home at a young age to be involved in camps, to be involved in tournaments, and the only people they know, their entire family becomes the other Taekwondo people. If they're to report or to complain about what happened to them, they have no support structure outside of this sport. Taekwondo is even worse than others because it's a martial art. You bow down to the person that is the coach. You revere them as more than a coach. You don't question them. That is part of the martial art. And so when you have this situation, it is ripe for abuse. And in that case, there were no governmental immunity issues that they could be sued on state law, but they could also be sued on what's called a TVPA claim, which is a federal statute, which is a sex trafficking claim. And
Is that because they were going across state lines or something to
they're
bring these
going over
kids?
state lines. They're
Wow.
going over state lines for their own economic benefit and
Okay.
transporting the athletes over state. I mean, some of the things that happened on the airplane going to, for example, the Pan American Games were too grotesque and explicit to explain on this podcast. But
Wow.
essentially, quid pro quo sexual mandates. If you don't do this, you're not getting off the plane type things.
Wow.
And so those were our allegations. Those are all outlined in the complaint and was reported on by various news entities. So typically we don't run into immunity issues on the Olympic sport cases, but in a lot of our other cases, we definitely do.
Yeah.
And that becomes really an issue when you're suing public entities like public schools. That can become a big problem. There's charitable immunity issues in different jurisdictions. There could be issues with suing religious organizations and schools and churches. They all have a variety of different immunities that they've enjoyed through the years that, in my opinion, they shouldn't, that you have to look out for. So it can get complex pretty fast depending upon where the events happened and looking at the immunity stuff.
And it brings me to my next question, which is how do you screen these cases? And what I'm imagining is we've got listeners that are Colorado trial lawyers primarily, and somebody calls up their office and says, I was sexually assaulted. What types
Sure.
of things are you looking at when you're deciding whether to embark on such a civil case?
The two first things that we look at is, one, is there somebody to pay? And if this is going to be a case against an individual perpetrator, do they reasonably have some assets to compensate the person? Because it's a big lift to get somebody through a sex assault case. It can be re-traumatizing. And a lot of the time, I'm tempted to say most of the time, but a lot of the time they want to have that experience because it's cathartic, that it's therapeutic,
Wow.
that it gives them some control over their abuser. So
Yeah.
I'm not suggesting that all victims of abuse that this should be avoided, but certainly a topic of conversation about, are we going to go through this process to get no money? And that's, so one, is there somebody to pay? Number two, what happened on the criminal side of things? And those are the two real paramount things, that if they never reported it to the police, well, why not? And there can be reasons that are valid,
Of
but do
course.
they need to report it now? Because there's a lot of jury issues and issues that come up, that this is important enough to sue about, but not important enough to make a police report. And so that's an issue. And then if it were reported to the police, what happened? And so those are really the two paramount issues. In that, in our third party cases, and third party cases are where we're suing a school or a camp or an athletic organization, a landlord. That's one we've seen a lot. We don't allege that the landlord committed the sexual abuse. We don't allege that the United States Olympic Committee, the people on that committee, committed the abuse. What we allege is either premises liability or negligence, or another tort that they knew or should have known, but because usually of their financial interests, turned a blind eye and didn't protect the people that they had a duty to protect. And so those are the two issues. And then the third issue, of course, is no different than any other case, is statute of limitations. Is in Colorado, we have a real bad problem with statute of limitations that the legislature fixed, and then our Supreme Court, in their wisdom, threw out.
So talk to us a little bit about that, because I imagine we've got Colorado lawyers listening. Walk us through the landmine of the statute of limitations as it applies to Colorado sex assault claims.
Sure. So traditionally, against a perpetrator, so that's not a third party claim. That
Okay.
means the person who did it or allegedly did it, you would have 6 years.
Okay.
And for a minor, you'd have till their 18th birthday plus 6. So till their 24th birthday. That's
Yep.
the traditional setup. And then the traditional setup against third party claims was 2 years, because it's either going to be likely a premises liability claim, or it's going to be a negligence claim, and that would be 2 years. So if it's a child, that would expire when they're 20 years old. That's the
Yep.
traditional setup.
Okay.
Nationwide, what was being seen and what is still being seen is, especially children cannot always appreciate their injuries or need to sue. For example, let's assume a coach is having inappropriate sexual contact. It's a little redundant. Inappropriate sexual contact. It's obviously inappropriate. So it's
Okay.
having sexual contact with a minor child when they're
Yep.
16,
Yep.
when they're 17. Well, when they turn 18, the statute will traditionally start running. When they're 20, when the statute runs, they may be still under the control of that person.
Ah.
Okay,
Yeah.
where
Yeah.
they practically can't speak up, where there'll
Right.
be retribution, where there'll be consequences if they speak up. So other states have gone on and gotten rid of statute of limitations for minor children that were abused years ago. A lot of people, we've heard from a lot, were abused at camps, private for-profit camps, when
Okay.
they were 10, 12, 11, back in the 90s, back in the late 80s. And other states have recognized that it's not until you're an adult that many people realize how harmful that is, and reflect back and say, oh my God, this did happen to me. And I was given every tool by the people who did it to explain it away, to rationalize it, to say it's all right. And it's not until you're a parent yourself that you understand that this happened to you. And other states have fixed that and allowed those people to sue. Colorado fixed that and allowed those people to sue too, creating a look back of many, many years. I don't remember what the look back period was, but it was like 30 years or 25
Okay.
years or something
Yeah.
like that.
Yeah.
And the Supreme Court threw it out. They said it was unconstitutional, that essentially when the statute of limitations expired on the rapist or the people empowering the rapist, that was a vested right. That was a vested right that they enjoyed in not having that claim pending against them anymore. And that under our Colorado Constitution, it was their interpretation that the statute had to be invalidated. So part of the statute survived. And the part of the statute that survived, although it's still under attack by the Chamber of Commerce, by the churches, I'll let you know that your school districts that you pay money for, that you
Yeah.
pay property tax to, it's under full attack by all those. They've hired private lawyers. They're looking to get rid of these things, which raises a real question as to whether you're okay with that you're paying property tax for public schools to try to make it up, to make them not subject to lawsuits when they allow rapists to be teachers. But setting that aside, the rule now is, I believe it's a 2022, if the statute of limitations had not expired on a sex assault claim, either against the third party or against the perpetrator, as of 2022, and I don't know what date in 2022 because I have to check every time,
Okay.
then there is no statute of limitations going forward. And the idea behind that is those people didn't have a vested right in the statute of limitations having expired against them because it hadn't expired yet as of the time of the statute.
Okay.
So right now, this is a very long answer to a very simple question you asked. What's the statute of limitations? Is right now, for cases that happened many, many years ago, those cases are probably gone and nothing can be done.
Yep.
For cases that happen in and around now, there likely is no statute of limitations moving forward on sex assault claims.
Okay. Well, what I like about that answer is I understood it and feel like I have information moving forward. So let's talk about the trial that you recently did in Jefferson County. Give the listeners, I guess, what's the factual backdrop of what happened, and if you don't mind, what was the verdict, and then we can get into some of the nitty gritty.
Sure. So the most recent case we tried was a couple weeks ago in Jefferson County, and we represented a child and her mom. I'll call the child Morgan. Morgan's mom was divorced and a single parent and had met a man named Damian Kea. Damian Kea was a real estate agent and real estate investor. They started dating, and at some point they became serious. And after a period of years dating, Morgan's mom and Morgan moved in to Damian Kea's house. Shortly thereafter, Damian Kea proposed to be married to the mom, and the relationship was such that he invited Morgan to be present during the proposal, the marriage proposal. She was happy, thrilled to have him in the family, viewed him as somebody that she loved. She had known him since she was 9 years old. They're proposed to be married when she was 12 or 13. So for a 9-year-old, that's like a long time, right?
Yeah.
So unfortunately, he proposed in May of 2021, and it didn't take him very long to take advantage of that situation.
How so?
Um, while living under the same roof as Morgan and his mom. One night, what happened is Morgan and her mom were watching a TV show in bed together, which was an issue in the case. And mom falls asleep. Mr. Kea gets into bed. The three of them are in bed. She's 13 years old. Mom asleep, and he sexually assaults Morgan. There was digital penetration repeatedly. He touched her breasts. He touched her nipples. He touched her genitals. She sort of pretended to be asleep. She didn't know what to do. She was shocked. She then pretended to be asleep a while longer after it had finished. She went back into her own room, cried herself to sleep. She told herself every reason in the world why this wouldn't happen again. She's 13 years old.
Yeah.
She hoped it wouldn't happen again. She didn't know why it had happened. About a month and a half later, she and her mom, again, are in bed watching television. Mr. K is not home. He's out with some friends. He comes home late. Again, mom falls asleep. Same thing happens again, except this time she testified that she could see his phone, the flash on his phone, presumably taking images of the abuse.
Wow.
The next morning, she gets up. It's a Saturday. She tells her mom, Mom, we need to go for a drive together alone.
Okay.
Mom's concerned. When your 13-year-old tells you you need to go for a ride together alone, you know there's a problem.
Yeah.
She couldn't make the words. She couldn't make herself say that Damien sexually assaulted me. It was too much. And she knew that the second she reported this, because she's 13, but she's not stupid, that the second she reported this, she would have to tell her dad. She would be embarrassed that the love of her mom's life would be out of their life, that they would have to move, that they would have nowhere to live, that she may have to change schools. All these things she knew would happen the second this was reported. And she handed her mom a piece of paper that said, Damien sexually assaulted me. She hands it to her mom while they're driving. Mom pulls over and is in absolute tears. Feels absolutely devastated.
I can't even imagine. You and I both have kids right at that age. I just cannot even imagine hearing that from your daughter. It's just unbelievable. What happened after that?
They report to the police. Morgan gets counseling. She works on a book with her therapist. She prepares this story because she's exercising avoidance with her therapist, that she has depression. She's been cutting herself after this.
Oh my God.
She's been burning herself after this, which for those of you who don't know, those are actually not suicide attempts. Those are acts of self-harm from trauma.
Okay.
That she says that the blood from the cutting represent her tears. But she has difficulty, in her therapist's words, with the issue of avoidance, that because they're unable to make real strides in therapy, that she's resorting to the cutting, the burning, and other destructive behaviors. So she works with her therapist to write a story about what happened to her, but it not being her. So she writes a story about a princess and a hero and a monster. And she writes this amazing story that she's the princess, her mom's the hero, Damien is the monster. And this story will bring you to tears, how Morgan thought that the monster would go away. Morgan thought that the monster could be tamed. Morgan thought that the monster would stop being a monster. But the monster only got worse over time. And by ignoring the monster became more aggressive. And by ignoring the monster wanted more and more.
Wow.
And the monster then made it worse. And at this point took pictures of her and The only thing she could do to get out of the situation was to kill the monster by telling the hero or her
Oh,
mom.
yeah, yeah, yeah.
And she read this story in the criminal court to the judge during the sentencing. And I'll tell you, he pled down, way down, to a crime that was not sexual assault of a child by a person of a position in trust. And I'll also tell you that it's apparent that she was completely ignored by the judge and everybody there.
Well, and let me jump in. Let me jump in on that because I was a crimes against children prosecutor in Jefferson County, and there is the Victims' Rights Act. Did the family not feel like the prosecutors listened to what they wanted to see happen on that case, or was it they were okay with the plea bargain because they didn't want to go through a criminal trial type situation?
They weren't okay with the plea bargain, and they made that known. And although they were given input, all of their input was ignored.
Yeah. Wow.
And he pleaded down to a nothing charge. Apparently, what Morgan had to say was not heard and by the judge. They hired us to sue him after that, and the perpetrator, Mr. Kea, took the position that it never happened.
Yeah, I was going to ask you, I don't mean to interrupt, but as part of the criminal sentencing, did he accept any responsibility or was this a complete denial type of? In other words, there weren't any statements made by the defendant that you could utilize in your case, or is that incorrect?
There were several statements made by the defendant that we could use in our case, but nevertheless, they did not admit liability. They contested liability until the whole time. So we sued him on the basis of outrageous conduct, assault, and battery.
Okay.
We did a week-long trial. We put mom on the stand, dad, the divorced dad,
Yeah.
who was heroic, having this happened in over something that he had no control over to the person he loves most in his world. We called the therapist, who was incredible, and some other lay witnesses.
What about your
We also
client?
called what we called our client. We put on the defendant in our case in chief, which did not go well for him. And the jury came back with a $2,020,000 verdict found for us on all claims, on all three. I'll tell you that they did a statutory offer before trial of $45,000, which they increased to $50,000. And then it was strange, they kept sending us every few weeks a new statutory offer for $50,000, which I can't understand doing that, but they did. So
Okay.
the most they ever offered was 50,000. They took the position, the defense took the position at trial is to award no money, or in the alternative that her therapy, I can't remember if they said they did a breakdown. I think it might have been $12,000 or $18,000, but that's what they wanted. That's what they thought they were going to get too. We had some jury questions that came out that, I didn't really view as positive or negative for us, but the defense clearly viewed as positive for them, given their reaction to it. They thought they were going to win the trial.
Okay.
So the jury came back after a 5-day trial, and our clients are very pleased.
What did you ask for in damages, and how do you go about formulating a damage model on a sex assault case?
Well, that's a really good question, because we talked a lot about how we would do this, and for those of you who know me, my experience is largely in medical malpractice cases, and proving damages in those cases is a lot easier, frankly, because you have a life care plan. Usually have big medical bills, and so sometimes you have $1 million of past medical bills, and those aren't hard to prove. Those are easy to get in. Then you have a life care plan of usually can be several millions of dollars depending on the case. And you can get those things through a life care plan or use an economist for your wage law. And so this is different, and we've had to learn how to do this. But the way we did it in this case, we do it differently in everyone. The way we did it in this case is in the CMO, we put in that we were going to claim past meds in the way by way of pediatrician visits and antidepressants
Okay.
and therapy. The problem is that adds up to like nothing,
Right.
right?
Right.
I think it's like $5,000 or $7,000.
Yeah.
And we viewed that as a significant anchor in the case. And then we had an expert witness who was going to testify, among other things, a clinical psychologist, that she would need $45,000 of care in the future, which I didn't really think was that persuasive. It's just not enough money.
Yeah. Yeah.
So we came up with a different plan. And the plan that we came up with was to ask every therapist who testified how much they charge their clients and how much they're charging to be at trial,
Okay.
which is invariably more than they charge their clients, right?
Yeah. Yeah.
So we did that. And at the end of the case, we knew that there were three categories of damages that we had to hit on: economic, non-economic, and physical impairment. Now, the physical impairment battle is the biggest one in these cases.
That's what I was just thinking is it's, again, forgive my ignorance, but how do you explain to a judge that physical trauma from a sex assault is impairment?
So that's why I think this case is notable, because I don't think there are many cases in Colorado where a jury has found physical impairment as a result of emotional trauma. And this is
Yeah.
this is what we did. And this was our plan from day one as to that category.
Okay.
We had the treating therapist, who was a rock star, and our retained forensic psychologist endorsed to testify that the literature shows that trauma of this magnitude, and it's five things: sexual assault that is severe, that's penetration of her genitals,
Yeah.
by a person of a position of trust, in her own home, while she is a child, that is repeated.
Wow.
Those five aggravating factors amount to such sufficient trauma that it physically impairs the brain. And you can say it one of two ways, and they're probably both right. That this magnitude of trauma physically impairs the brain and changes the way the brain works. It changes the way the person now reacts to trauma, reacts to stress, reacts to depression, all those things.
Yeah.
And the data and the science supports us on that. Or you can explain it differently, that this abuse causes PTSD, and PTSD is a physical impairment of the brain. That's what
Yeah.
PTSD is.
Yeah.
That if you have PTSD, you have physical impairment of the brain. They're both right.
Did you have an actual diagnosis of post-traumatic stress disorder by a psychiatrist on your case?
Yes.
Okay.
Not by a psychiatrist, by a psychologist.
Okay.
Now, there was a huge dispute about that. The defense position was this was created by the lawyers, that
Yeah.
nobody diagnosed her with PTSD until we got involved. That wasn't true. What was true is in the weeks after the assault, the treating therapist diagnosed her with PTSD. The issue there is that you don't give psychotherapy clients, especially minor child, their own file. You don't give them records. So they're saying there's no contemporaneous notation or finding of PTSD, which they're right. But under Colorado law, there never will be, because that's you only get a summary from, under Colorado law, you only get a summary from the therapist at a break in therapy. And that's usually when the lawyer asks.
Okay.
So there was a big dispute about whether she had PTSD or whether that's something that we created as her lawyers. And so the reason that was fought so ferociously on both sides is we knew we needed the diagnosis of PTSD in order to prove physical impairment of the brain. The jury ultimately agreed that there was physical impairment of the brain and put about almost $500,000 on physical impairment.
Okay.
And we think that's really notable, because we can't find another verdict. There may be one, but we can't find another verdict where in a civil case, a sexual assault victim proved physical impairment, not from physical injury like being beaten, but from
Yeah.
the emotional aspect of it. And we think that this is a notable case that will help open the door to other survivors of sexual assault, where in mediation or whatever, trying to get cases settled, to say, well, what are you talking about? We're not, you're not going to be able to prove physical impairment. Well, we now have a verdict form finding that.
Yeah, walk me through that a little bit more if you don't mind, because I have not litigated that issue, but I was aware that PTSD can cause changes in the brain and that there's certainly an argument for physical impairment damages arising from PTSD. And usually I seem to see this in brain injury cases and things along those lines. So what kind of resistance from the defense did you face, and were these retained experts you used to testify about that, or were these treating doctors, or some combination of the two?
Sure. So the way we had it set up before the trial is that two treating therapists would come testify that she in fact has PTSD, that they diagnosed her with PTSD on their own, that they diagnosed her with PTSD before I ever spoke with them, that the reason that it wasn't known to the child or the family is Colorado law and privacy, and that they could have revealed to the child that she has PTSD, but what's the purpose?
Okay.
And that she had PTSD, and that PTSD is a physical impairment of the brain. And they
Okay.
had books and literature along with their own training that they were endorsed to testify to.
All right, let me stop you real quick, because I want to give kind of a practice pointer on this issue, because it seems like we always end up with non-retained treating physicians in which we can sort of say in the 26A2 disclosure what their opinions are and what they rely upon, and then you have retained experts. So am I hearing you say you had non-retained treating medical providers that were going to give you PTSD, and then you met with them and discussed various literature that supports that that is a permanent impairment of the brain, and then in your disclosures you disclosed that they would be talking about that support? Did I get that right?
Yep, that's
Okay.
right.
All right.
That's exactly right. You call them and say, listen, I know you've been seeing Morgan. Would you be comfortable writing a summary of your care? And, I'll tell you what the lawsuit's about, and this is what it's about. We need to know what she's been struggling with. They'll usually tell you on the phone what they intend to put in the summary.
Yep.
And, we would typically raise, do you feel, is it your opinion that PTSD, or the trauma that causes PTSD, it's really a distinction without a difference, it causes a physical impairment of the brain? And every good, well-trained therapist is going to tell you, absolutely, that is our training. Absolutely, that is what my experience is. And in following patients, that is apparent. And that especially the people that have been trained in more recent years are more comfortable with that concept. People trained 30 years ago are less comfortable with that concept. And this is not something that we ask them to do. This is something that they wanted to include, that they feel very strongly about, because in their field, in their experience, this is not that controversial. When somebody has such trauma that causes major depressive disorder or PTSD or both, can you just choose not to be depressed? Can you just choose not to have racing thoughts? Can you just choose to not think about it? Can you choose not to cut yourself? Can you choose not to harm yourself? Can you choose not to have suicidal ideation? The answer is no, because everybody would choose not to if they could. That the brain is not processing information like it did before this trauma. Can the Vietnam veterans that went through a living hell just pretend like it didn't happen? Can the people in Afghanistan that saw their friends get blown away just pretend like it didn't happen? Can people sexually assaulted by their stepfather just wish it away? Just ignore it?
Yeah.
Like the Book of Mormon said, just wish the gay away, right? That's not the reality. And so they were very comfortable in doing their endorsement in that way. And then on top of that, we used a retained expert who really who was like a researcher, and she really explained more of the literature and the progression of literature over time and how they have found these things. And, I don't think our treaters could tell you that, oh, there's these areas of the brain. It's the amygdala, which it is, the hippocampus, which it is. And they didn't really know that. And to
Right.
them, that's not that important. But our retained expert could tell us that those are the areas of the brain that have been found to be impaired. We didn't call
Okay.
our retained expert. We just made it what she had some scheduling issues, and we decided not to accommodate those scheduling issues to lengthen the trial. So when we ran into some scheduling issues, we just thought, you know what, we don't want the jury to come back on Monday. And I'm not even
Right.
sure the judge would let them come back on Monday. So we went without her.
And just for educational purposes for our listeners, did I hear that PTSD can actually, is it a shrinking with like a neuroquant analysis that parts of the brain they can actually visualize the, I don't know if it's atrophy that occurs to sections in the brain or anything about that that you can help educate myself and our listeners?
Yeah, you have to be really careful because you don't want to plead yourself into a situation where they say, if this is true, why didn't you get an MRI of the brain? And then we just see. And because as we all know that all impairments of the brain can't be seen on imaging.
Yeah.
Imaging, it's only as good as the camera that takes the imaging, which is an MRI or CT. And so if you could see all injuries to the brain, they would just put one on the NFL sideline, and every time somebody got their bell rung, just put them in the machine and say yes or no. But that's not the way, we're not at that point in science yet. So you want to be really careful that, to say that imaging can show these impacts. The imaging can show these impacts in some people, and it's not known which people show these things or not. The problem is, as a practice pointer, is if you get too much into that these problems can be seen on imaging, it begs the question, did your client then have imaging? And the
Yeah.
answer is going to be no. And then if they did have imaging, did it show any problems? The answer is going to be probably not. The gold standard here is not imaging. The gold standard here is function. And if you meet the DSM-5 criteria for PTSD, the type of which is very specific and almost universally followed,
Mm.
if not universally, certainly the standard of care to follow the DSM-5 criteria. If you have that metric of trauma, then it is presumed that there's been a physical impairment of the brain. That's why your body's acting that way. So I would be very cautious talking about the imaging. You can certainly talk about the the articles that then reference the imaging, but the person needs to be prepped to say, listen, yeah, to some people it's been seen on imaging, but imaging doesn't show everything at this stage of science. Maybe in 10 years it will, maybe in 30 years it will, but right now it doesn't. And I expect that most people that have PTSD, whether it's from Afghanistan, whether it's from Vietnam, whether it's from sexual assault, that they will probably have perfectly normal MRIs, or else you're going to plead yourself into a real predicament.
I learned that lesson the hard way. And I'm reminded of something I've been listening to on other podcasts, which is be careful what you set out to prove. Because we had a brain injury case and we were talking about DTIs and, oh, look at this DTI and look at this brain imaging. And the whole case became about that. And when that expert didn't really stand up so well and that piece kind of fell apart, I felt like our entire brain injury piece of that case kind of fell apart where we didn't really need it because we had great before and after witnesses, contemporaneous complaints, and things along those lines. So it's really landing on me strongly about be careful what you take out to prove. Sounds like you threaded that needle perfectly in your case.
Yeah, and also, I think to some extent trials become about what you talk about, and that the more you talk about getting a fight over the imaging, the more the jury is going to think that must be a dispositive issue. Where if you
Yes.
if you don't even bring it up, you know, the other side brought it up on cross with our therapist and she disposed of it. I thought she was brilliant. They said, it's true that you don't have any imaging showing this. And she said, and I wouldn't expect there to be
Right.
that, that most people with PTSD, one, never get imaging. And two, The imaging wouldn't show this. It's a clinical diagnosis.
Yeah.
And this isn't, and I think you use the DSM-5 in conjunction with that, which has very specific criteria,
Okay.
and go through it and say, this isn't something that we just imagine. This isn't a diagnosis of exclusion. This isn't something that we just feel that you have. You must meet each of these criteria. And not until do you do that will we give the diagnosis. And I think that was very persuasive to the jury.
A question for you is for people that are listening to this, and obviously these are extremely righteous cases to bring, and they're interested in trying to get involved in these cases. Number one, do you have any sort of trial pointers on the best way to present these cases to a jury? And then number two, even bigger picture, what do you tell some young lawyer who's listening that thinks, I would really love to pursue justice in the civil arena for victims of sex assault cases?
Yeah, I think the trial pointers are, one, talk to your client often about their desire to go to trial.
Do you empower
That
them? Is that like make it
no, I think that may be empowering, but they have to want to have a trial.
okay?
I think if their reaction is, I I do not want this, I cannot have this, that you need to respect that. And especially, where in a car crash case, not to diminish car crash cases because you have terrible, terrible injuries, but a lot of people aren't wondering why this happened to them. If you get rear-ended, the idea that this might be their fault, the idea that they may have invited this, the idea that they didn't see it coming, all those issues aren't usually involved in a rear-end car crash case, where they are in a sexual assault case. Almost everybody wonders, why did this happen? How did this happen? Did I not see the signs? How could I have prevented this? Am I somehow at fault for this? Did I
Yeah.
do something that invited this? And even though we as lawyers say that's not true, you shouldn't feel that way, they feel that way. And so I would say talk to your client often about whether they feel a trial will be helpful to their mental health, something that they want to do, or something that they feel will cause them to have a complete breakdown. And take that into consideration. So that's a trial point. The next trial pointer that I have is sort of a sad one, that all the jury attribution issues that we talk about, that, for example, in our case, Morgan had gone to 37 therapy sessions and then had done another 7 with somebody else, then I think another 5 with somebody else. So they had done like 50 therapy sessions for a kid. For a kid between 13 and 16, 50 therapy sessions. It gained traction amongst some, not all, some of the jurors that there were gaps in treatment.
Wow.
That the jury was saying, here the therapist said to do group therapy. You never did group therapy. Who's going to do group therapy? You're going to bring a 13-year-old with a group of other people and say, talk about your stepfather sexually assaulting you? Of course
Wow.
not.
Wow.
Of course not. But it was recommended. And because it was recommended, they didn't do it. One of the defense jurors really glommed onto that and said, they're not doing the things that they should be doing to get better.
Wow.
And so you asked for the trial points that I thought were important. One, talk to your client about going to trial. The next is, even on the small issue, the issues that you don't think are serious, like not getting treatment, make sure you preempt those things or talk about them in voir dire if you can.
Okay.
I'm not saying not to take the case, but the things that I thought weren't terribly persuasive, at least one juror thought was persuasive. The next question I think you had is, what are the points to a young lawyer considering taking these cases?
Yeah.
I think the biggest point I have is that you probably need a man and woman on your team. Number one, you don't know who they're going to connect with the best, and that we have a male and a female on every one of these cases.
Okay.
Sometimes it's with me they connect the most. Sometimes it's with a woman that they connect the most. But they should have that opportunity.
Yeah.
And two, be trauma informed. And what that means is if somebody calls you with a sex assault case, we usually say, not always, but usually say, listen, this is horrible. I'm going to tell you right now, we are not going to go through what happened with the assault. We're not going to go through the assault today. We're not going to talk about it. We're not going to talk about it. We're going to talk about other things. We're going to talk about how you're doing. We're going to talk about how work is. We're going to talk about whether there's a criminal case. We're going to talk about irrespective of what happened, when it happened, to make sure we have the statute of limitations done. And you wouldn't believe that I would say 8 times out of 10, they say, oh, thank God. I was getting, I called a lawyer and I was all prepared to talk about these things. And I really am so glad we don't have to today.
Mm-hmm. Yeah.
And read the room too. We met with somebody the other day, which is a 16-year-old who is a potential case. They were molested, and their mom's sitting next to them. You think they want to go through with that with you, with their mom sitting next to them? So don't ask. Do it another time, or do it another way. There may be a time when you have to ask, but it's not the first meeting. It's not the first couple of meetings. People don't tell secrets to strangers, and at that point, you're a stranger.
Yeah.
And don't put them in that position. For people that are have really serious abuse or things that they're going to have difficulty talking about, we never ask, and we just send them to a forensic psychologist, and we let the forensic psychologist, whose entire job it is to get this information, and who is a woman, get that information from them. We may have to follow up, but let her get that information, not you. And certainly don't ask. By the way, we've had other cases where there's been alleged sexual assault and they come with their boyfriend or their girlfriend. You will not get the truth as to what happened. And I understand that. You can't expect them to tell the truth with their boyfriend or girlfriend sitting right next to them. There may be a lot of history there that you don't understand. And people are not living in a vacuum with a perfect life up until that moment that they get sexually abused. So it's not worth asking in the presence of others because you're going to get some version of the story that you're going to take as true. That's not true.
So, thank you so much for sharing your wisdom with us and this most righteous cause that you find yourself engaging in. If people want to get a hold of you, want to pick your brain about a case, what's the best way for people to get a hold of you?
Call the firm at Parker Lipman, 720-638-9424, or my email, dan@parkerlipman.com. And one of the things, Keith, you asked how we described the damages. I didn't want to ignore that we did ask for non-economic damages in that case. I just didn't want to leave that hanging out there. But given the caps, we wanted to funnel as much as we could into physical impairment.
So you got almost $1 million in non-economic damages?
We got 1.2 in non-economics, which we think will work fine because we think the judge is going to double the cap. If she doesn't double it here, when are you going to double it?
Right. And I guess oftentimes on these cases, because I'm assuming a lot of the cases you're involved in occurred some time ago, we're talking significant prejudgment interest on these cases. Am I right about that?
Yeah, we should get a lot of prejudgment interest and plus costs. The way we argue the damages, I would encourage people to really think about whether you're going to have an economist or a life care planner. I don't think it's going to come out in these cases like you think it is. The way I argued it is I said, listen, you heard that the therapist gets paid $150 an hour. She gets paid $150 an hour to deal with this problem that Morgan has. You also heard from the judge instructed you that that Morgan's gonna live another 65 years, whatever it was. Now we all know that if the therapy rate is $150 today, it's not going to be that in 20, 30, 40 years. It's going to be a lot. But okay, let's just take $150. There will be some days that Morgan deals with this all day.
Yeah.
And all night. There will be some days, maybe even weeks, when she doesn't deal with this at all. There'll be some days when she deals with it a minute. There'll be some days when she deals with it every minute. Sometimes all night, not during the day. Sometimes all day, not during the night. It's going to go like that for the rest of her life. Every time she's depressed, she's going to wonder, am I depressed because I was sexually assaulted multiple times by my stepdad? Or is it normal to be depressed? She now has to ask herself that question every time she's sad, upset, whatever. So if it costs $150 to pay somebody else to deal with this for 1 hour, don't tell her her time's worth any less.
I like that.
And if we just assume she has to deal with this for 1 hour a day for the rest of her life, that's $150 a day times 365 days times 60 years. That's $3.3 million.
Wow.
And you don't get a bulk discount in Colorado for sexual assaults because that's what she'd need if it happened one time. So you have to double it because it happened twice. Unless you want to tell this defendant that it's okay to do this more than one time, you got to double it. And I'll tell you, Keith, that we were one juror away from them doing that. So the one juror who thought it was influential that she didn't go to as much therapy was a real anchor in our case and a real problem for us. But this goes to what we've been learning over the last maybe 3 years or whatever since COVID, that to shoot for the stars and maybe you'll get what you want if you do that.
Well, it's still a phenomenal result. So one juror away from a truly extraordinary result, but holy cow, amazing result and justice for your client. I guess, did your client's mom get divorced from this man?
Yeah, I said it was the stepfather. They actually never went through with the wedding once they found out about this. So
Okay.
it was de facto stepfather.
Okay, got it. All right. Well, Dan, it has been a true pleasure. Thank you so much for taking time to speak with us today. And until the next one, thank you, listeners, for listening. And we'll see you next time on the Colorado Trial Lawyer Connection podcast. Thanks, Dan.
Thanks, Keith.
Thank you for joining us. We hope you've gained valuable insights and inspiration from today's courtroom warriors. And thank you for being in the arena. Make sure to subscribe and join us next time as we continue to dissect real cases and learn from Colorado's top trial lawyers. Our mission is to empower our legal community, helping us to become better trial lawyers to effectively represent our clients. Keep your connection to Colorado's best trial lawyers alive at www.thectlc.com.